927.
Yeah.
And so what Mr. Justice Buckley was contemplating was the general meeting exercising its own power, not a power of ratification. And of course, when it did so, he could take the view, of course, the general meeting can decide for itself whether it wants its majority position changed with the issue. And he also didn't suggest that the general meeting could add on 10 votes per share. In fact, nothing that Mr. Justice Buckley says in Hogg could lead you to suppose that he meant ratification of an improper purpose.
Sorry, I don't think those articles confer any power on the company in general meeting to issue shares, do they?
The company in general meeting may increase the capital by the creation of new shares.
That's the increase in the authorised share capital.
But they may
That's
be
not
issued on
concerned.
such terms and with such rights or privilege as the general meeting resolving upon
Yeah.
the creation may so direct.
But that's the authorised share capital. It's not issuing
Yes.
the shares in the capital.
No, but
And then it goes 14, the directors, yes.
I mean, I think the point was whether there was something in the articles which conferred on the expressly conferred on the shareholders a right to authorise or direct the issue of shares, and I think the answer is no.
But when they issued the 5707 shares, that was increasing the preference share capital, if you like.
I mean, the shareholders had passed a resolution increasing the capital,
Yeah.
but the issue of the shares was by
The directors.
the directors.
Yeah, but it was all done in one go. Well, if you look at what happened, it's described. Let me just find it. And the answer to your lordship's question is that that's the only provision that deals with the share issue.
Yes, and Article 14 provides for the directors to make the allotment.
Yeah. Anyway, what I say happened is that Mr. Justice Buckley thought that, and you see then Mr. Justice Plowman discussing the reserve power of the general meeting to approve share issues in great detail, and he's taken. Lord Justice Harman makes fun of that.
Well, you're in,
Sorry, what are you
When we
talking
get
We're
to
in Bamford now.
we'll get to Bamford in a minute. I'm just finishing Hogg.
So you said someone discusses something in great detail. Just help me.
Okay.
What are you talking about?
Mr. Justice Buckley doesn't discuss in the judgment where the general meeting gets its power from. We've looked at whether or not there's an article dealing with it, but he says he's told that the general meeting might approve of the share issue, and he convenes a general meeting rather than setting aside the share issue.
Yes.
To see what its views are. And of course, if its views are, we quite like the EBT, then he's not going to exercise his discretion to set aside the share issue. That's how I read it. And there is then, as you see it in the footnote on the last page, the general meeting, which does approve the share issue, and so that's the end of it. When we get to Bamford in a minute, you'll see that Mr. Justice Plowman spends most of the judgment investigating whether the general meeting has a reserve power to issue shares. And you turn to Bamford, which is at 5331. And just before I do that, I should just summarize what I have to say about Hogg. Mr. Justice Buckley doesn't invite the general meeting to ratify an improper purpose. The commentators understood that it was authority for ratifying an improper purpose. That's Wedderburn 8484 and 8486, and also Seeley at 8432.
Sorry, could you just give me the Wedderburn one again, please?
8484, that's a case note in the Modern Law Review.
Yes.
Another one, 8486, he says it. and then it's the same article, and then at 8432, Seeley says it. And Mr. Justice Plowman also thought that 5355. I'm sorry, make sure. No, let me get to that in a minute. Anyway, the point about the point about this is it's Hogg and Cramphorn is often cited incorrectly, we say, for the proposition that Mr. Justice Buckley thought you could ratify an improper share issue. The ratification that occurred in Bamford is set out at 5334. It was a counter to the writ action to set aside the share issue. They held a meeting and approved the share issue. And in...
So, at 5334 we see... What do we see there, sorry?
We see the, between letters A and D, you see the ratification.
I see. Counter to that. Yes.
And between letter 5336 up to the bit I want to show you on 5342, the judge deals with an argument about the place of the general meeting and the directors. Starts at 5336.
Where does it start?
He says he's summarising Francis's argument.
Yes.
And he's saying that a simple majority, that is just above E, simple majority of shareholders in general meeting has only such powers as the articles expressly confer on it, can't alter the articles. Whether simple majority in general meeting has a power to direct how unissued shares shall be allotted, construction of the articles, true construction of these articles, the power to allot these shares was vested in the directors alone. They had no power to delegate that power to the shareholders in general meeting. And then he deals with automatic self-cleansing filter in all those cases that deal with the role of the board in the general meeting. And Shaw and Shaw is the last thing he refers to in that line of cases at 5341 at the bottom. And 5342, he says, that just by letter F, if you allow a general meeting to determine how shares shall be allotted, you are altering the whole nature of the power. It's a fiduciary power for the protection of the minority, and if you allow it to be exercised in general meeting, you're allowing it to be exercised by persons who are entitled to consult their own interests, and who, unlike the directors, are not bound to consult only the benefit of the company. And then he goes on, the validity of these arguments depends, I think, on the question whether Articles 12 and 53 leave a residual power of allotment in the company. If they do, then my judgment, there's no question of altering the nature of the power, because the residual power is the company's, not the directors. The company exercises in own right and not in right of the board. And then he summarises the argument on the other side, which he accepts, and in particular draw your attention on 5343 that he to the duty to be exercised bona fide in the interest of the company.
Where are you reading from, please?
This is sorry, letter A on 5343.
543.
Proposition number 2.
5343.
Yes, sorry, 5343.
Letter A.
Letter A, proposition number 2.
Applies to all powers of the directors, namely that they should be exercised bona fide. Well,
Yeah.
That's hardly controversial.
No, it isn't. And then he accepts these arguments at C. There's no argument, though, that they're exercised for a proper purpose. And there's no argument that the company itself has an obligation to the member. And then he deals with this at the
Can I just
Sunday.
ask, did this analysis survive in the Court of Appeal?
No,
No,
it didn't.
okay.
But it's noted.
Yeah, right.
Well,
I genuinely didn't
it
know.
might help the board if you tell us what you're wanting to take out of Bamford before we look at these passages.
Well, he says at 5346. Plowman incorrectly, we say, refers to Hogg and Cramphorn at 5346, and he doesn't explain anywhere in this judgment why the general meeting can ratify a claim that the member has. His reasoning is confined to really to G on 5346, in my judgment, having gone through at some length to show that the company had a residual power to issue shares.
So in other words, it wasn't really a ratification, it was an exercise by the company in general meeting of its power to issue shares. That was
Yes.
Mr. Justice Plowman's analysis.
Yeah.
Yes.
And it was not argued, as you saw, that the plaintiff lacked standing, so theoretical ratification was not tested.
No, I mean, Bamford, nothing happened to undermine the plaintiff's standing until the vote at general meeting. It wasn't concerned with any theoretical right to overrule, to approve what the directors had done.
But at no stage does the court say, well, because of Burland and Earl and because of what Lord Justice Jenkins says, and you're on the first rule, you don't get to court, you don't have standing.
Yeah.
And when you get to Lord Justice Harman, they give two rather different judgments in the Court of Appeal. Lord Justice Harman starts at 5356. And he recites the notice of appeal on the second ground. He says he finds that very odd, and you can. I get nothing from the next passage until we go to 5357, where he refers to Regal, Hastings, and Gulliver at letter C. And Lord Russell refers to the fact that you could, by resolution, antecedent or subsequent, they could have got their liability to account set aside by the general meeting, so that the noble lord considered obvious that they could, by obtaining either previous approval or subsequent ratification, retain the profit. And then you see he says that the directors, in fact, did make an allotment. Well, we've been through that. We know that they give you legal title when they make an allotment. He then says there's no doubt that the LLTs are on the register, and left this by 3 lines between F and G. The only question is whether the allotment, having been made, as one must assume in bad faith, is voidable and can be avoided at the instance of the company, at their instance only and of no one else, because the wrong, if wrong it be, is a wrong done to the company. So he doesn't consider that the members ever had claims, never discusses any of the authorities in which members have had claims. He says the wrong is done to the company, which is essentially the proper purpose rule, the proper plaintiff rule. And he says because it's a wrong done to the company, everything else really follows from that. The wrong can be ratified and so on. But that wouldn't be possible if it was a wrong to the individual, and he doesn't discuss at this point why it's a wrong done to the company, not the individual. It might be both. And Lord Justice Russell does the same thing on page 5361, between letter E and F. And he says the point marches in step with the principles of Foss and Harbottle. None of the factors that admit exceptions appear to exist. So he hasn't considered the personal rights exception at all, not been addressed on it, no reference to Lord Justice Jenkins. And then he goes on to say the harm done by the assumed improperly motivated allotment is a harm done to the company, of which only the company can complain, because he never considers that it might also be a harm done to the individual and give the individual...
Well, when you say the individual...
sorry, the member.
Which member?
a member who finds his majority
I see.
trashed, or a minority that finds its shareholding block trashed.
But there wasn't a majority shareholder, was there?
In Bamford, no, I think it was a minority that complained about the takeover.
Yes, but I mean, isn't the point about Bamford that it diluted everyone equally?
Yes.
Yeah.
So
Maybe.
it wouldn't be a matter, would it, of the member complaining? It would be all the members complaining.
Yeah.
I mean, they're all victims. I mean, isn't that a big distinction between Bamford and your case?
Well, Excavators, which you remember was the related company in Bamford.
They were the principal supplier.
No, that's...
Oh, forgive me.
The principal supplier was Burgess Limited.
They were the allottee, weren't they?
Yeah, 533, Burgess Limited is the
So
distributor.
what's the point about Excavator? They were the bidder.
They're minority shareholder. They made a complaint because they wanted to make a bid. And basically Bamford had given these shares to...
So what was the interest that was damaged in their case was not an interest as a shareholder,
Precisely.
It was an interest as a prospective bidder.
Yes, I mean, all the shareholders were affected equally, qua shareholder. And what it was a dispute about the company's policy. Should X bid or should Y bid? It wasn't about, which your case is about, if your allegations are made out, that the directors have exercised their powers as part of a conspiracy against a minority shareholder, which is a very, very different territory.
Yeah, you found a much simpler answer for me to Bamford than I thought you might find a simpler one. But I had one or two other points to make about Bamford. But in particular, that if it can't be used to explain or to explain away the claim of an individual member, because it wasn't considered. Both Lord Justice...
I mean, it does seem to be a significantly different case, and I'm not sure it's really, in any sense, an obstacle to your case.
Well,
It was held against me, so, I'm dealing
Yeah, I
with...
follow that. Yeah.
Yes.
Was it actually the Court of Appeal actually relied on this, did they?
I don't know if...
I'm not sure they did.
no, but one of the other cases called Gower did, and Gower was...
Gao, that's the other Cayman case.
Yeah, yes, Mr. Justice Cayman. They did rely on that.
Yeah. Anyway, what you say about it is, well, this issue was just not considered.
Exactly. Yeah. Residues deals with ratification. You remember, I think I showed you the passage at page 7561. So halfway down the first column into the second column. I'm just giving you that as a reference.
Which page number?
7561. You asked me for some form of authority about the duty owed by the company at the same time as fiduciary duties. What I say to that is, I'm going to show you something in Gower. The references for this are in our case at 5032, paragraph 60A. But Gower's fourth edition, which was the last one he, I think, authored on his own, or had made a substantial contribution to, at 8129. Says, in the derivative action explained, it lies where wrong has been done to the company. Where, however, wrong is being done or threatened by the company, different considerations apply. The company then is not merely a nominal defendant, but the real defendant, because judgment's required against it, and the proper plaintiff is anyone who has a personal right against the company which is being infringed. The reason why the decisions are so confused and confusing on the question of whether the action should primarily be by the company or against it is because the same facts will often give rise to both possibilities. The company is proposing to do something ultra vires or which infringes the articles, shareholder may properly pursue to restrain them, but alternatively the company itself may proceed against its directors. Now, all the cases where there is a personal right of action, you're likely to have that duality. purpose formula is simply another example of where both the company has a duty because of the articles and the contract with its members and the directors. And Davis makes the same point, but he's probably doing that because he then becomes an editor of Gower, but this is not Gower.
But for your purposes, the key point is the last sentence of the paragraph that goes over the page on 8129.
Yeah. Yes.
The second alternative is the possible one. No reason for a reason without member to sue the company if he has an independent right to do so.
Yeah. Thank you.
0830, actually, I think, isn't it?
Yes, that's where the paragraph ends.
Yeah.
And when you're looking at other breaches of the articles where the member does have a right, it will frequently be the case that the directors have failed in their duties to comply with the articles, which is also a duty. And then one line. Davis makes the same point on page 8102. It's the third edition introduction to Company Law 2020. However, the courts have analysed what appears to be similar cases. Sometimes as in the end. And then he says
This is
what
just
seems to have arisen out of a failure by the courts at the top of the page to distinguish between two different articles in breach of the articles. The directors failed to observe the articles, they will be in breach of duty to the company, as we saw. On the other hand, if the directors cause the company to act in breach of its articles, the company will be in breach of the contract with its shareholders.
Could I just say that 8102 is a single page from this book, and
I thought
it might just be helpful to see a little bit of context.
I'm sorry about that. Yes, it would be. I'll get you the chapter overnight.
Thank you.
Thank you very much.
I mean, the same thing can be said of the Companies Act, where you don't have one of the relevant sections, so I can know that too. And that was. I don't need the extra minutes. I think I've probably exhausted your patience by now.
Thank you very much. If you just bear with me a second.
Sorry,
my computer has been playing up. I'm just trying to get it restarted.
Just before I spoke too soon. Page 166 of the key documents, the judgment of the Court of Appeal. The Court of Appeal makes the point that it isn't a loss suffered by the company; it's a loss that they see we have suffered as well.
That's paragraph 46, is it?
End of 46.
So what point are you making?
Well, it's the distinction between one of the distinctions with Bamford, I suppose, where they think of it as a loss to the company. In our case, we have a block. We are different. We're not like every other shareholder.
Well, in your case, you're saying that you've been targeted.
We've been targeted, yeah, because of our shareholding block.
Mr. Lowe, just on, while we're on, or I was on, things included in your bundle, my Lord Sales referred this morning to Jessica, is it Hudson's article, which starts at page 8356. The point I just wanted to make is this: we don't have the footnotes.
I know, I've got them, so I can give them to you.
Well,
If you
that I
could have
welcome.
them sent to us.
I'd be interested to know what footnote 29 is.
Sorry, what?
It starts at, it's tab 142, starts at page 8356.
8356?
8356.
And the footnote that your lordship was interested in was which one?
29.
29.
I think we'd like all of them.
Yes. 29 refers, so just so you know, refers to Elaine, Duke of Portland, Metoy,
Well, I think strictly, I've got another copy. Doesn't it refer to note 13?
Which is what note 13
then
refers to.
That then has a series of cases.
Yeah. So, unless there's anything else that anyone...
No, thank you very much. Thank you. I've managed to retrieve my system. Thank you.
Thank you.
I'm sorry to delay you.
Not at all, my Lord. My Lords, in our submission, this appeal concerns the route by which an individual shareholder in a company can bring an action in respect of an improper allotment of shares in the company, which is affected by the directors of the company. In our submission, the correct analysis is that an improper allotment of shares in a company affected by its directors for an improper purpose gives rise to a cause of action by the company against the directors for breach of duty and for exercising their power for an improper purpose, and potentially also against the recipients of the shares to set aside the allotment of the shares. Now, if the company fails to pursue that cause of action, then an individual shareholder may be able to do so by way of derivative action, but subject to the usual well-established requirements for bringing such an action. Conversely, if the majority shareholders in the company acting in good faith take the view that the allotment should stand, then the minority shareholder will be bound by that decision. The shareholders' agreement to abide by the decisions of the constitutional decision-making bodies of a company in this respect is a fundamental part of the bargain which is made when becoming a shareholder in the company. And what, in our submission, a minority shareholder cannot do and should not be permitted to do is circumvent that framework by bringing its own claim against the company, the directors, or the third-party recipients. Now, in our submission, the approach which I've just described strikes a careful and appropriate balance between two competing considerations. The first is the nature of a company and a shareholding, and the fact that by becoming a shareholder, a person agrees to abide by and be subject to the constitution of the company, including decisions made by a majority of the shareholders. That's one consideration. The other competing consideration is the fact that in certain circumstances, it may be necessary to permit a minority shareholder to bring the company's claim, most notably in a situation where the majority are acting in some way oppressively of the minority. And in our submission, the way that balance is struck is by requiring the action to be brought by way of derivative action. Now, so far as the personal cause of action is concerned, which is relied on in the present case, which is asserted to exist and relied on in the present case, in our submission there's two fundamental difficulties with that. The first in our submission is there simply is no cause of action by a shareholder against the company in respect of an improper allotment. The cause of action which exists in our submission is one which belongs to the company, albeit a shareholder may be entitled to bring it in certain circumstances by way of derivative action.
Saying that there's a cause of action by the company doesn't preclude one by the shareholder, does it?
No, it doesn't.
They're not simply alternatives, so you could say that because there's one, there isn't the other.
Correct. So our submission is that the cause of action by the shareholder against the company for an improper allotment just doesn't exist. And the cause of action in respect of an improper allotment is one that belongs to the company. So putting it in the language of Foss and Harbottle, the company is the proper plaintiff. And the second fundamental problem in our submission is that the existence of the alleged personal cause of action presupposes that an individual shareholder may have a cause of action for an improper allotment, even if the allotment is ratified by a majority of the shareholders acting in good faith. And in our submission, that is flatly inconsistent with what we've described in our case by way of shorthand as the majority rule principle, but essentially the second aspect of the rule in Foss and Harbottle. Now, I'm going to come on and develop those two propositions in turn.
Sorry, just on your second one, you put it in terms of even if ratified by shareholders in general meeting.
Yes.
So that seems to be looking to see whether there is a ratification in fact later on, whereas
Yes.
I had understood your argument at this stage to be, and it's enough if it's ratifiable in principle.
That's correct. What
That shows that there isn't a personal claim.
Yes, sorry to interrupt you. Yes. Yes, the point I'm making is it's the logical consequence of my learned friend's case that this personal cause of action exists, that a shareholder may be able to bring that cause of action even if there has been ratification of the allotment by the majority acting in good faith in the general meeting. And in our submission, that is inconsistent with...
I'm not sure he needs to go that far, does he?
He's going that far.
Well, certainly the way he's put it...
Well, there are two different points. You can make one point or the stronger one, but the fact you could make the stronger one doesn't invalidate the lesser one.
No, it doesn't. But as I understood it, the way the argument is put is to say there is this personal cause of action. It said you can't ratify the improper allotment. The majority can't ratify the improper allotment. The personal cause of action exists, and therefore what that is contemplating is that there may be a situation where the individual shareholder is entitled to bring a personal cause of action in respect of an improper allotment, even where the majority, acting in good faith, have said, no, we think this allotment is actually in the best interests of the company. And that's the logical consequence of my learned friend's case. And
It doesn't actually, on the facts of this case, as pleaded,
not on
need to go that far.
Well, he may not. I mean, may have to look quite carefully. We may have to look quite carefully at how it's been pleaded and what is the cause of action that's relied on so far as the pleading.
No, but I don't understand why it's a logical consequence of his case.
No.
If the essence of his case is that a shareholder may be able to bring a personal action
Yes.
if the company's constitution has led to the denial of some right which he has under it.
Yes.
If it's acknowledged that, generally speaking, the majority acting in good faith and not oppressively can decide on a certain course, even if it dilutes his shareholding.
Yes.
Well, then he doesn't have an action once that's happened.
Well, but that's not in fact the case that's been put against us. The case that's been put against us is to say you can't ratify.
Oh, that's a different point, though, isn't it? Whether or not you can ratify is a separate question.
Yeah.
Even if you can, the shareholder still has a cause of action, which is your supposedly second conclusion.
Well, no, because what he's hypothesising by saying you can't ratify, that means that the individual shareholder will have a cause of action. So what their case leads to is a situation where the individual shareholder, say an allotment takes place for an improper purpose, on his case the shareholder will have an individual cause of action against the company for the improper allotment. The majority shareholders in the company seek to ratify that. As I understood it, it's put on the basis Bamford and Bamford is wrong. In fact, they can't ratify that, even if they purport to do so. And the individual shareholder, therefore, retains...
Those are two different propositions being put forward, aren't they?
Yes.
The first might be right, that there is a cause of action, and the second might be wrong, that that the shareholders can't ratify.
They are two different... They are absolutely two propositions. And
I have to say, I thought both were being covered because page 7561,
yes.
the judgment of Chief Justice King in the residues case, right-hand column,
Yes.
which I understood Mr. Lowe to be adopting, at least as part of his argument,
Yes.
puts it precisely in terms of you have locus standi to sue, and that exists until, in fact, the infringement is expunged by ratification. So you sue, as an individual member, you're at risk that something might be done to take away
Yes.
or nullify your cause of action. But that doesn't mean you don't have standing to sue until that does happen. And of course, here it said actually it couldn't happen because the majority at a general meeting would not act in good faith. And
Yes.
so you never get to ratification in fact.
Well, I understand that. I think that perhaps is rather different to the way it's put in 98 to 100 of my little friend's written case. And that, I think, if I may say, it presupposes a slightly different cause of action, because you're then saying you have a personal cause of action as a shareholder in respect of an improper allotment, unless and until the majority acting in good faith ratify. So it's, if you like, a conditional or qualified cause of action.
Yes,
So,
but that is a way of reconciling the majority principle that you've referred to
yes.
with individual claims that people do have up to a certain point.
Well, yes, but then you have to identify the basis for that conditional cause of action. So what you're effectively saying is there isn't a cause of action in absolute terms for an improper allotment. You have, in effect, a conditional cause of action until such time as there is...
Well, it may be a defeasible cause of action,
Yes.
and it may be based on the fact that what's being alleged is a conspiracy to remove a negative control of the company, which is a harm done to the individual shareholder.
Yes. Well, it may be what's now been said that there is this defeasible cause of action.
This is actually their pleaded case.
That there is this defeasible...
Yeah, well, they put it in paragraph 65 of their amended statement of claim at page 36 in the bundle. The resolutions ratifying the specific mandate could not have ratified the issue of the bonds and shares as, that's to say, because ACC and the others were not acting bona fide but for the improper purpose. So that is precisely saying that it was an invalid ratification.
No, I understand they said that. That's absolutely what they plead on the facts of the case. I was just on a rather different point, which is identifying the legal nature of the cause of action, which is said to exist between the shareholder and the company where there's been an improper allotment.
But why isn't that just a breach of contract?
Well,
it's a defeasible breach of contract in that it could be put right later on by a valid resolution by the shareholders in general meeting. But unless and until that happens, it's still a breach of the article.
Well, in our submission, it isn't a breach of contract. I'll come to this. It goes to our point on the nature of the cause of action. But in our submission, the way in which the law has analysed the question of improper allotment is by reference to the relationship between the company and the directors. It looks at the question of the exercise of the powers given to the directors. If those powers are exercised by the directors for an improper purpose, then there is a cause of action between the company and the directors and potentially the recipients of any shares. But none
yes, well, that's the breach of fiduciary duty.
Exactly, and none of that involves in our submission the individual shareholders necessarily having their own causes of action.
But it doesn't exclude it either. I mean, we go back to what Lord Leggett was putting to you. You can have both.
Yes,
and we know that the contract, I think it's a Section 25 contract in Cayman, gives the members contractual rights to have the articles observed. So they start off, if you like, on the front foot, that they have a contractual right to have the articles observed.
Well, I mean, I respectfully take issue with that. I mean, they don't have a contractual right in terms to have the articles observed. There isn't a... What Section 25 says is that the articles will form a contract between the shareholders, all of them, and the company. Now, there isn't within the articles anything that says expressly each individual shareholder has a right to have the articles observed. And indeed...
If you've got a contract between A, B and C, A, B and C can enforce the contract.
Well, yes, they can, but we're talking about what rights the contract gives them. And
you're saying the contract gives the shareholders no rights?
No, I'm not saying that, no. I mean,
but that's the issue, isn't it?
No, the question...
Whether this does give rise to a right enforceable by a shareholder.
In respect of an improper...
But there are clearly plenty of rights arising under the articles which as a matter of contract are enforceable by a shareholder.
Absolutely, and we don't dispute that at all.
We don't need anything expressed in the articles to say this is enforceable by the shareholder.
No, but you need to identify a right in the articles which is given to the shareholder. And what we're concerned with in this case is the question of improper allotment of shares. And in our submission, when we come to this, you don't find anything express in the articles on which you can hang a hook for the existence of that right. There's one suggestion in the pleading and implied term which we'll come to, which I'll deal with, but there isn't, for example, an express right in the articles not to be subject to an improper allotment. There's nothing in the nature of an express preemption right or anything of that nature which is at issue in this case. Now, so what I was proposing to do, subject to your lordship, is start with the question of the nature of the cause of action for an improper allotment. There's then certain points of policy which we make as to why the personal claim both isn't necessary, also why we say it isn't appropriate. I'm then going to pick up the other authorities to the extent I haven't done so already. And then fourthly, deal with the question of ratification, and then fifthly, the question of void or voidable. Now, so starting with the question of the nature of the cause of action for an improper allotment of shares, in our submission, the way in which the law has consistently analysed this question is by reference to the relationship between a company and its directors. In particular, as in the present case, a company will typically have the power under its constitution to issue shares. But as your lordships know, since a company is a legal person, those powers fall to be exercised by the company's directors as its agent. And the exercise of those powers by the directors are subject to constraints, and to a large extent, those reflect the constraints which typically apply where a fiduciary is given powers to exercise on behalf of someone else, and those include what's described as the proper purpose rule. Now, in our submission, what's important is the way that the exercise of those powers is regulated is through the nature of the relationship between the company and the directors. The company is the donee of the power to issue the shares. Sorry, the company is the donor of the power to issue the shares, and the directors stand in a fiduciary relationship to the company vis-à-vis the exercise of that power. In essence, the company is the donor, the directors are the donee. Alternatively, if you put it in terms of duty, the director's duty to exercise their powers for a proper purpose is a duty which is owed to the company. And in our submission, these points, they're not, they ought not, we suggest, to be controversial, but they clearly follow from the analysis of the proper purpose rule provided by the Supreme Court in the Eclairs case. And if I can just show you that very briefly, because it emphasises the way in which this is analysed in terms of the fiduciary and trustee relationship. Eclairs is at 5727. And the relevant judgment is that of Lord Sumption. And I think we can just pick it up at 5735, which is paragraph 14.
14?
14, yes, my lord. And this section of the judgment describes the nature of the proper purpose. For your lordship's record, my Lord Hodge agreed with Lord Sumption. Lords Mant, Newberger and Clark essentially reserved their position on the causation test for assessing whether the relevant decision of the directors was tainted by an improper purpose. But in my submission, that reservation doesn't affect the description of the proper purpose rule, which is set out here. Now, just looking at what Lord Sumption, how he describes it, at the start of paragraph 14, in the second sentence, the proper purpose rule is stated in section 171B of the 2006 Act, which provides that a director of a company must only exercise powers for the purposes for which they are conferred. The rule thus stated substantially corresponds to the equitable rule, which had for many years been applied to the exercise of discretionary powers by trustees. And then he refers to Balls and Strutt. And then paragraph 15, the proper purpose rule has its origin in the equitable doctrine, which is known rather inappropriately as the doctrine of fraud on a power. And your lordships in a subsequent case have suggested it may be better to stop using that particular expression. And then he refers to some of the older cases, including Duke of Portland against Topham, where Lord Westbury, Lord Chancellor, had stated the nature of the rule. And then at the bottom of the page, the important point for present purposes is that the proper purpose rule is not concerned with an excess of power by doing an act which is beyond the scope of the instrument, creating it as a matter of construction or implication. It is concerned with abuse of power by doing acts which are within its scope but done for an improper reason. And then paragraph 16, he then explains why it is that applies to company directors at all. A company director differs from an express trustee in having no title to the company's assets, but he is unquestionably a fiduciary and has always been treated as a trustee for the company of his powers. Their exercise is limited to the purpose for which they were conferred. Now, the application of the proper purpose rule, therefore, in our submission is founded on the fact that the director is a fiduciary and a trustee vis-à-vis the company of his powers. The relevant relationship which gives rise to the application of the rule is the one that sits between the company and the directors. The directors, nor indeed the company, are trustees or fiduciaries for the individual shareholders. And if we just complete this, your lordship will note, for example, paragraph 23 on 5738, he refers to Howard Smith and Ampol. And then
in a matter of agency law, if an agent exercises their authority, let's say in bad faith, it's not just a breach of duty by the agent to the principal. It's an unauthorised act which doesn't bind the principal.
Yes, subject to ratification, exactly. Yes. So that's why I say when the company has the cause of action against the directors, it may also have a cause of action against the allottees of the shares. And
yeah, but it also means, doesn't it, that shareholder isn't bound by the purported exercise of power by the director on behalf of the company, because it was done for an improper purpose. It wasn't a valid exercise of the power, and therefore it doesn't bind the other parties to the contract.
Well, the shareholders aren't a party to the contract. And
are they not? I thought they were party to the contract created by the...
Well, they're parties to the articles.
Yes.
But you're talking about the contract of, on this hypothesis, the contract of allotment.
I think
I'm talking about the claim in the case, which is some of the shareholders complaining that something was done that doesn't bind them because it was done for an improper purpose.
Yes, well,
and if I may just say, and hence without authority.
Yes.
So in other words, I think, if I may say so, what my Lord is putting to you, and I wanted to put the same, is, might it not be said that due fulfilment of the agency role of the directors for the company with respect to exercise of the company's powers depends upon them fulfilling their obligations to the company itself? And that means that, if that's right, that would indicate that fulfilment by the directors of their fiduciary obligations vis-à-vis the company is itself a condition of them duly exercising their powers, their authority to act in exercise of the powers of the company. And then, if a shareholder is entitled to complain, well, this power has not been exercised with due authority on behalf of the company, in effect, the shareholder is relying upon the breaches of duty by the directors owed to the company in order to show that there wasn't authority at all.
Yes. So I think there's perhaps two different issues at play. The first is the question of whether the transaction will be binding on the company. And obviously, if a director enters into a transaction for an improper purpose, then it may well not be, depending on questions of ostensible authority and ratification.
Yes.
Yeah.
But what we're concerned with at this stage of the analysis is identifying the basis for a cause of action by the shareholder against the company. So we have before us here a claim, an unusual claim, which is brought by an individual minority shareholder against the company. And as we understand it, the basis of that claim is said to be that there is a cause of action which exists in favour of the shareholder against the company for an improper allotment. Now,
well, he's trying to say it was invalid.
Yeah.
Yes, and
so isn't that? I mean, one way of looking at it is to say that take Eclairs, take the fact of Eclairs, because it may be simpler. There, the claimant's shares had been disenfranchised by a decision taken by the directors under the articles.
Yes.
The claimant's argument was, well, there was no valid disenfranchisement of our shares because the directors exercised that power for an improper purpose.
Yes.
And therefore, our shares are not disenfranchised lawfully.
Yes.
Well, why can't the same argument apply in this case?
Well, you could if that was what they are asserting is that they have a cause of action as between the shareholder. Are you
saying that in Eclairs the claimants didn't have a cause of action?
No, I mean we can come to Eclairs, but that's a rather different case, and that goes to the question of where you draw the boundary between the circumstances.
Can you explain why the claimants in Eclairs had a valid cause of action, notwithstanding that what lay at the root of their claim was an allegation that the directors had acted in breach of duty?
Well, in Eclairs, how it manifested itself was there was notices directed at the two specific shareholders and only at them, and the exercise of the power was directed at disenfranchising their shares and only their shares.
But it was what lay at the root of it was a breach of duty by the directors. You say, well, that's a matter the company can complain of.
Yes, and the question, and I'm not sure this question was necessarily ventilated in Eclairs, but the question in Eclairs would have been whether on those facts there was also a personal cause of action.
Well, that's I'm trying to explore with you. Whether you say is it your submission that the claimants in Eclairs did or did not have, properly analysed, a personal cause of action? And if so, what was its nature?
Well, it's not part of my case on this appeal to assert that they didn't have.
The problem is, on the face of it, your argument, your principal submission is wholly inconsistent with Eclairs. So I think this is really quite important.
Yes. Well, the difference in Eclairs is you had the exercise of a right which was directed and only directed at those two shareholders. The notices that were issued only related to those two shareholders, and the notices had the effect of disenfranchising only their shares.
Well, I appreciate that, but the whole case turned on an allegation that the directors had exercised the power for an improper purpose.
Yes.
And as I understand your argument, you say, well, that's a claim that can only be brought by the company because those duties are only owed to the company.
No, we're not putting it in that absolute terms. As I said, in relation to an improper allotment, where the directors exercise their power to allot shares for an improper purpose, and that consequently has the dilutive effect of diluting existing shareholders in the company, that gives rise to a cause of action by the company against the directors and not a cause of action by the shareholders.
It's the second stage. Yes, you're assuming because the company has a cause of action, the shareholder doesn't. I mean, the case against you here is that this particular allotment was directed against the claimants, just as the disenfranchisement was directed against the claimants in Eclairs.
Well, one needs to identify what the basis of the cause of action is.
And it's the directors acting for an improper purpose.
Well, but you have to identify why that is that gives an individual shareholder a cause of action. Because, I mean, the corollary of that position is that whenever a director exercises a power for an improper purpose, each and every shareholder in a company will have a cause of action against the company.
No, I don't think it does lead to that.
I don't think that follows.
Because here, the pleaded case is that this issue of shares was specifically targeted at diluting the claimant's shares.
Yeah.
So that would not obviously give a claim to any shareholder other than the claimant.
But then you have to...
So it's targeted in this, I mean, maybe indirectly, but it's nonetheless targeted at the claimant, just as the disenfranchisement notice was targeted at Claire's and its fellow claimant.
But then it's necessary to analyse why it is that the targeting means that there is a cause of action when there wouldn't otherwise have been one. Because if you take the building blocks in our case, our starting position would be if a director just exercises powers for an improper purpose generally and isn't targeting anyone, say, the cause of action only is between the company and the directors, and an individual shareholder doesn't have an individual.
Well, almost certainly, there would only, in any event, be reflective loss so far as the shareholders.
But then the quite critical question is, well, why is it that the targeting? Why does that create the individual cause of action? And what is the cause of action that is relied on, that is created by the targeting? Now, I mean, if one was talking about a conspiracy claim, one could perhaps understand that and say, well, if you're targeting me, that means I have a cause of action because I'm the victim of a conspiracy. In our submission, what's quite difficult to understand is how it is that targeting effectively extends the cause of action, so that it isn't only one vested in the company against the shareholders, but is vested in the targets, if you like. And
when you talk about the cause of action here, from my understanding, what's being sought is simply a declaration that an allotment of shares is ineffective.
Yes.
I mean, in a sense, that's a cause of action, because you need to be able to explain why, as against you or as against the company, it is an invalid allotment. But it's not necessarily saying, and I'm going to claim damages because of it or anything like that. It's at an earlier stage trying to establish this should not have happened because no organ of the company was properly authorised to do that thing.
Yes. So your Lordship's absolutely right that the relief that's sought in the prayer in this case is the declaration which your Lordship referred to. Your Lordship's also absolutely right that in order to seek a declaration you need to find some sort of cause of action
or explanation why this act is ineffective.
Yes, exactly. And as we understand it, the basis for the cause of action and the basis is for the declaration that's put here is it's said that there is a cause of action between the shareholder and the company for the improper allotment. Now, we made the point in our...
But just pausing on that. And as I understand it, the basis for them saying that is that no organ of the company had proper authority to make this allotment.
Well, I'd understood what they were saying was that the company has a power to issue and allot securities, and that power vested in the company was exercised for an improper purpose. And in other words, fraud on a power, and that it was that fraud on a power contention that gave rise to a cause of action between the shareholder and the company. So that's certainly the cause of action that's put in the grounds of appeal at paragraph.
Well, I have to say, I've been thinking of it in slightly different terms, that when looking at the question, could the relevant organ of the company validly exercise the power of allotment, the relevant organ here being the board of directors?
Yes.
The test for that is whether they acted in compliance with all their duties, including the duties that they owed to the company. And then it said, no, they didn't, therefore they didn't have authority to do this.
Well, yes. I mean, can I just show you paragraph 18 of our written case? Because I did contemplate this might be where the argument ended up moving towards. But so it does rather depend on the cause of action you're relying on to found your declaration.
Your point, as I understand, is this? Am I understanding it right? Is that standing in civil law normally depends on identifying a right that you have which has been infringed.
Exactly.
It's not simply enough to say that the company or the other party should have done something differently. You've got to show that it has, by doing so, it's violated a right of yours.
Exactly.
And that you say that right has to be pinpointed, and the appellant hasn't done so adequately.
Exactly right.
Is that right?
The cause of action which it purports to rely on doesn't exist. So, I mean, paragraph 18, we did sort of contemplate that this might be an issue where the argument moved into, because... sorry, 5060, my lord.
5060.
5060, paragraph 18. Because obviously, when one applies to the court for a declaration, there's a number of ways, a number of causes of action you might rely on. Now, one way in which Tianrui could have sought to do this is to say, well, actually, there was a contract here between the company and the recipients of the bonds and shares. We're a third party to that contract, but nonetheless, we seek a declaration that as between the company and the recipients of the bonds and shares, it is invalid as being in excess of the company's authority. Now, that would be one way in which you could formulate it. And that's not what's been done here, because what Tianrui is relying on is its own cause of action, which it says it has as a shareholder against the company. And that's the target which
if it weren't a shareholder, I don't see how it could have a cause of action of the sort you've just described.
No, of course not.
I mean,
no.
it's because it's a shareholder.
Yes. No, but
why as a shareholder... Yes, I'm not quite sure I understand what this claim to intervene between the... I can see they can apply to set it aside,
yes,
which is in fact what they originally did.
Well, they claim for declaration was void, yes. Yeah.
Well, they've sought to amend.
Yeah.
But
we
just come back to them being a shareholder, don't we?
Yes, sorry, perhaps I'm not making the point very clear.
I mean, third-party contract rights are possibly an example of private law where somebody has standing without being owed a duty or having a right as against the other party.
That's exactly right.
That's one way of analysing.
That's one way they could have done it.
Third-party contract rights.
Yes, that's one way you could do it. And whether you even need to be a third party to the contract, you just come along and rely on...
But it simply doesn't work here, does it? Absent their status as shareholders. I mean, they don't enjoy third-party rights under the contract between the company and the bondholders.
No, I'm sorry, I'm not being very, very clear. Well, what I was focusing on is that if you're applying for a declaration, there's a number of causes of action you might rely on. One way in which you might seek the declaration is by relying on the cause of action that in fact exists between two other parties, here the company and the allottees. So you as a shareholder might come along to the court and say, I would like a declaration as a third party that this allotment of shares was invalid because the company did it in breach of authority. And that might be one way you could frame your claim for declaratory relief. That isn't what they've done here.
I would have thought it was obviously demurrable, wasn't it?
Well, it may or may not be. I mean, I think...
What in those terms?
Well, we say it probably wouldn't work, but that's one way.
Anyway, they're not relying on it.
They're not.
You don't have to worry about it. You're saying they say they do. There is a right owed to them that's been infringed.
Exactly. So the nature of the inquiry, it seems to us, has to be to seek to identify whether that right, that legal cause of action actually exists as a matter of law or not, because that is what they rely on to found their claim for declaratory relief. And if you go to the grounds of appeal, the way you have to ask yourself, well, how is that? How do they formulate, how do they articulate that cause of action? What is it they say the cause of action actually is? And in our submission, what they rely on, and this is what my learned friend sought to rely on in his submissions this morning, is that they say the company has a power to allot and issue shares, and in this case, bonds, and that in exercising that power, the company committed a fraud on a power. That's the language they use, and that gives the individual shareholder a cause of action against the company. That, as we understand it.
Well, you have to add in exercised for the purpose of damaging them.
Yes, well, but
that's a sort of essential part of it.
Well, let's add that in as well. And in our submission, why that fails, that fraud on a power cause of action, if I can call it that, is that that doctrine of
improper purpose.
Proper purpose rule. Proper purpose rule might be the more up-to-date expression. Why that cause of action fails is that the proper purpose rule has no application between a company and its shareholders. The proper purpose rule applies as between the company and the directors, who are its fiduciary agents, who hold the company's powers on trust for the company. In that context, it applies and regulates the position as between the company and the directors, but it doesn't, we submit, have any application as between a company and its own shareholders. The company isn't in a fiduciary position vis-a-vis its own shareholders. The company doesn't hold any of its powers on trust or as fiduciary for its shareholders, and the concept of fraud on a power simply has no application between the shareholders and the company. So in our submission, that articulation of the cause of action, it simply doesn't exist as a matter of law. It doesn't apply. And as a matter of authority, I don't believe my learned friend has identified a case to your lordships which has involved the application of the proper purpose rule as between the shareholders and the company.
What about Howard Smith?
Howard Smith?
And Ampol Petroleum.
Well, and the whole row of Australian cases, which are either approved in Howard Smith or follow Howard Smith.
In turn, on the standing point, well, all those cases...
they're almost all about improper allotment of shares.
Yes.
And they're by persons who claim who are A, other shareholders,
yes,
and B, who claim to have been harmed in their relationship with the company,
yes,
by that allotment.
Yes, and all of them, I think, without exception, are cases where it's in effect brought by the majority shareholders.
Well, I don't think Howard Smith was.
Well, Howard Smith is the one exception. The fact,
right, well, it's a Privy Council decision.
Yes.
What do you say about it?
What do we say about Howard Smith? Well, on the facts of Howard Smith, the shareholders who in effect supported the action were the majority. As a matter of formality, I accept Bulk Ships was not formally a party to the claim. Ampol was. It was obvious from the facts. It was brought with the support of Bulk Ships as well.
Well, it was a claim by a minority holder.
Yes, as a matter of form, but with the support of... Well, perhaps we should look at the...
We will, but tell me, I mean, does it matter that it's a majority of shareholders who bring the claim?
It explains why it is that the point would not be focused on by the court if it's not taken, because...
Well, I wonder that. I mean, if you're right that the only claim is vested in the company, why does it matter whether it's a majority shareholder or a minority shareholder?
Because if the majority shareholder is bringing the claim and you as the defendant take a point on whether it's the majority shareholder or the company that should formally be the plaintiff, it's very unlikely to go anywhere, because all the majority shareholder has to do is pass a resolution requiring the company to bring the claim. So,
I mean, it could be quite important, but I mean, surely you've got to have the right claimant.
You do, and I mean, on Howard Smith and Ampol, I mean, Lord Wilberforce is quite clear. To make clear, this point wasn't argued in Howard Smith and Ampol.
Says it's not disputed.
It's not in dispute. It wasn't the subject of any argument or analysis. And when you get to...
I want to understand, actually, whether you say it should have been, and if it had been, the result would have been different.
If, in Howard Smith... Well, it was a point that was open to the defendant to take.
If it had been taken, your submission to us is that the decision in the case would have gone the other way, because the decision would have been the claimant, the plaintiff, had no standing.
Well, what would have happened in practice is that...
No, just as a matter of legal analysis, what is...
As a matter of legal analysis, yes. But as a matter of practice, what would have happened is the point would have been taken, and presumably Ampol and bulk ships would just have passed a resolution.
By the by, isn't it? Well, as a matter of the legal analysis, it was a wrong... You say Ampol, Harrismith and Ampol was a wrongly constituted claim.
Yes, we do say that.
Yes.
And the point wasn't taken, and it wasn't argued. And when you get to residues treatment, I think Chief Justice King, having been through all of those cases, in our submission rightly said none of them are decisive at the present point, and we respectfully agree. Fundamentally, you do have to find a legal basis for the cause of action that is said to exist between the company and the shareholders. It can't simply exist. There needs to be some legal basis.
But can I just test that against? Take Eclairs on one hand, which you say was just an individual notice sent to an individual shareholder.
Yes.
And take a case where a dilution has reduced a shareholder from 51% to 49%.
Yes.
I think you would say, well, they're on the opposite sides of this divide, because the dilution from 51 to 49 is just an improper allocation of shares.
Yes.
Whereas the disenfranchisement notice was a sort of personal act against a particular shareholder.
Yes.
But in the reality of life, the dilution of the 51% share to 49 was just as much directed at the 51% shareholder. I mean, let's assume.
Yes.
It was no less directed at him than a notice disenfranchising.
Yes.
And with probably not much less effect.
Yes.
And the disenfranchisement, I think, in Eclairs merely prevented somebody having the powers of a 25% plus shareholder.
Yes, I think that's right, yes.
It wasn't a majority situation.
Yes.
But aren't they both complaining about the same thing, which is that as shareholders of this company,
yes,
we are entitled to have the affairs of the company run in accordance with the Constitution as set out in its memonats, of which bind us all. And that memonats provides that shares will either be issued by directors, in which case they will have to do so in accordance with fiduciary obligations,
yes,
or by the general meeting, in which case it will have to do so in accordance with an obligation not to cause oppression, for example. I mean, let's just say the Allen and Goldreath's obligation.
Yes.
And why, if that's the claim, why is the cause of action any different between Eclairs and this case? In both cases, they're saying this company's constitution has been operated in a way which damages us.
Yes.
And we want to have that put right, as between us and the company.
Yes. Well, I mean, there's a number of points one making in relation to that. I mean, if you put it as broadly as saying the shareholder has a cause of action whenever the Constitution is operated in a way that's detrimental to them, you're effectively driving a coach in horses through both aspects of the rule of Fox and Harbottle and derivative action, because you're saying that an individual shareholder will always have a cause of action whenever the constitution of the company has not been operated in the right way. So whenever there's been a breach of duty by a director, whenever anything else has gone wrong, the corollary is you're saying the shareholder has an individual cause of action, and that...
No, I don't think that is what Lord Rex has put to you. Actually, he specifically put it in the context of the director's action being targeted at and having the effect of damaging that particular shareholder. So it wouldn't apply across the board.
Well, I mean, if you narrow down the cause of action in that way, then I ask rhetorically, why is it that the targeting supplies means a cause of action exists when it wouldn't otherwise exist?
Because there's a personal non-reflective loss suffered by the shareholder.
Well, in our personal
the company hasn't suffered a loss, but the shareholder has.
Well, but merely because you suffer a loss doesn't mean you have a cause of action.
No, but it makes all the difference between a shareholder who wants to complain about some breach of the Constitution which hasn't caused him a loss, and a shareholder who wants to say, A, it was targeted at him, and B, it caused him a loss.
But that applies equally to a minority. What if you're 26% and you go down to 21%?
Well, exactly.
That's what we're talking about.
Yes, exactly.
I know, but where do you... Well, I mean, it applies at every stage, doesn't it?
Well, and what's wrong with that, you may say?
Well...
I mean, if this is a deliberate infliction of damage on that particular shareholder.
Well, I mean, I didn't want
in breach of duty.
I mean, I think. I mean, I don't want to repeat myself, but I think in our submission you have to go back and ask yourself, what is this cause of action that is said to be relied on here? If you start from the proposition that ordinarily an individual shareholder won't have a cause of action against the company for the constitution not having been operated properly or the directors having not acted for a proper purpose, then you have to ask yourself, well, what is it that means that there is a cause of action that wouldn't otherwise exist? I think what's now been said, oh, well, it's the targeting that makes the difference. But one asks, well, how as a matter of law is that said to give rise to a cause of action? I mean, as I say,
because I think the point is that on the one hand, I mean, the point has been put to you by my Lord Briggs that on the one hand, the shareholder is entitled to the constitution being properly operated by the directors. That's to say, they will exercise their powers in accordance with the equitable duties which apply to them. And on the other side, that the result of their misfeasance in that respect is to inflict personal non-reflective loss on the shareholder. So it's the combination of that wrong on the one hand and the nature of the loss suffered by the shareholder on the other. I mean, you're quite right that company law does not permit shareholders to bring claims for any breach of duty, but company law operates in quite a pragmatic way in this respect. I mean, the exceptions to the rule in Foss and Harbottle, or particularly the fourth, the true exception, is in essence a pragmatic solution to a problem which otherwise exists.
But then, I mean,
but it's a perfectly principled thing to say that there's a wrong and there is specific loss suffered by the claimant, thereby giving the claimant a cause of action.
So, I mean, if one hypothesizes that is the cause of action, I mean, what that would mean is
the cause of action, I would say, is the breach of the articles, or there is the alternative way of putting it, my Lord Sales has put forward, that this is an unauthorized, Lord Legate, is simply an unauthorized act by the company, and is that not, or not properly authorized, and is therefore not effective.
Well, you need to look at, I mean, the question of unauthorised act in our submission is rather different, because that's looking at the position as between the company and the allottee of the shares, and effectively you're saying, well, that transaction just isn't effective. Well, what is relied on here is the cause of action between the shareholders and the company. Yeah. And if my lords are going to say, well, there is a cause of action by a shareholder against a company where there is an improper allotment carried out other than in accordance with the articles, and that causes non-reflective loss to the shareholder in question.
It's designed to do so.
It's designed to cause non-reflective loss
to the claimant shareholder.
Yes. I mean, I suppose one answer is, why does it make a difference that it's designed to cause loss to the shareholder?
Well, because that's what makes it improper.
Well, you may have allotments which are improper simply because they're carried out for the reasons in reasons in Bamford and Bamford, Hong and Crampthorne, just to block the takeover.
I think those are different cases. It wasn't targeted. It wasn't actually targeted as such. It wasn't designed.
Yes.
It affected all
You're
the
saying, though, it's a bit
themselves.
hard to make targeting itself a decisive factor. I can see it could be the reason why there's an improper purpose.
Yes.
And then maybe the second ingredient could be that the individual has suffered loss, which is not the company's loss.
Yes. And
so what's wrong with that approach?
So the two elements would be it's a not
improper purpose.
Yeah.
Whatever that might be, but it causes loss to the individual.
Well, then, whenever you have an improper allotment, each individual shareholder would have their own cause of action against the company. And fundamentally, I mean, I'm going to come to these points in due course. I mean, one has to ask, what is wrong with requiring it to be brought by way of derivative action? If the majority is acting oppressively...
You're not going to get a remedy, are you, for the individual shareholder?
The company suffers no loss.
Yeah. But that's if you have an improper allotment, then that affects all shareholders equally. They're all diluted in the same way. Then it's meaningless to think of them having all having a damages claim against the company. They'll all have the same damages claim against the company for the diminution in value of their shares.
I mean, I can see that because that's a sort of Bamford type of case. But supposing what the directors do is to issue shares to certain shareholders only, with a view to increasing their shareholding, particularly for the purpose of diluting the claimant's shareholding.
Yes.
With that, you'd say that only the company could complain of that.
Yes, and all of the individual shareholders are affected by that.
But some of them beneficially, because they get their shareholdings are being increased.
So if the shares are given to some of the shareholders,
issued, maybe they're paid up, but it's done for the purposes of diluting the claimant from 29% to 21%.
But then in that scenario, that's exactly when the minority shareholder has a derivative action against the allottees of the shares to set aside that allotment, and they just bring that to restore the status quo.
Is that right?
Yes, in my submission.
Well, if the directors acted in what they bona fide believed to be the interests of the company, and it was not an unreasonable decision, so would they fall within an exception?
If the directors act for what they bona fide believe to be in the best interest of the company, but it's nonetheless an improper purpose, that's still...
That's Eclairs.
Exactly.
The directors did so believe in Eclairs.
Exactly.
And that is Eclairs, but that's a personal action in Eclairs.
That's an infringement of the proper purpose rule still. And if the minority shareholder wants the company to bring an action in breach of that, but the majority oppressively stop the company from doing so, it would be able to bring a derivative action.
Really?
Yes. Well, yes, because that's exactly the wrongdoing control.
The wrongdoer control is one half of it.
Yes.
It has to be a dishonest breach of duty, doesn't it?
I don't believe so, but I will. I don't believe it has to be a dishonest breach of duty, but. If I'm wrong about that, I stand to be corrected. That's not.
I mean, maybe a deliberate breach of duty is enough.
I can't remember quite how it's put. I don't believe it's put as a dishonest breach of duty, but if I may, I will.
Yes, of course.
I'll check that and come back, because I don't want to mislead my lord. Become a little bit sidetracked as the arguments developed. How we put the argument is if you look at the cases which are concerned with improper allotments and look at the way in which they analyse the issue, they analyse the question in terms of the proper purpose rules and the constraints placed on directors as fiduciaries in the exercise of the powers to cause the company to allot shares. And if we... there's a number of cases, and in our submission it's quite a common thread. If I can just give you, my lord, some examples by reference to the principal authorities. The first is Punt and Simons at 6714. And this is a case where the directors had issued the shares for the purposes of creating a voting power in the company. If you go to 6723 in the report, you can see the finding on the facts that was made. It's about 2/3 of the way down the page.
I'm sorry, I think I got the wrong reference.
6723. So I'm in Punt and Simons, Mr. Justice Byrne.
Yeah, thank you. Sorry.
And about 2/3 of the way down, there's a sentence, on the evidence, I'm quite clear that these shares were not issued bona fide for the general advantage of the company, but they were issued with the immediate object of controlling the holders of the greater number of shares in the company and of obtaining the necessary statutory majority for passing a special resolution, while at the same time not conferring upon the minority the power to demand a poll. And you can see the way in which the legal analysis goes at the bottom of that page is that a power of the kind exercised by the directors in this case is one which must be exercised for the benefit of the company. So it's looking at the position between the directors and the company, and essentially on the footing that the directors stand in a fiduciary relationship vis-à-vis the company. And if you go over to 6724, it's about 8 lines down. About 6 lines down after the semicolon. But when I find a limited issue of shares to persons who are obviously meant and intended to secure the necessary statutory majority in a particular interest, I do not think that is a fair and bona fide exercise of the power. And he's quite plainly talking about the director's power, which they're exercising on behalf of the company. And then 6725, page 517 of the report. If I find, as I do, that shares have been issued under the general and fiduciary power of the directors for the express purpose of acquiring an unfair majority for the purpose of altering the rights of parties under the articles, I think I ought to interfere. And in our submission, it's all analysed in terms of the improper exercise by the directors of the power vested in them by the company to issue the shares. And in our submission, you get the same from Piercy and Mills.
Yes, but who was the claimant in this case?
It's the majority shareholders. It's one of the.
Why would they have standing on your approach?
Well, let me just. If you go to 6719, just to explain, if you go to the very start of the judgment, and I think it's the second sentence, the plaintiffs sue in a double capacity, first as trustees of the testator, with whom the company entered into an agreement containing the stipulation to which I've referred. Secondly, shareholders complaining of a misuse of their powers by the directors in issuing shares with the purpose and object of enabling a minority to control the majority. And the shareholders in that case were the majority shareholders in the company.
They were the majority until the directors purported to do what they did.
That's right, yes. Now,
so they were the minority by the time they brought the claim.
Otherwise, one assumes they didn't know how to go to court.
Yes, that I think is right. Though obviously, the decision was that it was invalid because it was in breach of the proper purpose power.
Yes, and what the minority shareholder was able to obtain was an injunction against a general meeting where the new majority could ratify the breach of fiduciary duty.
That's correct. So if you go to 6714, that was essentially the motion that was sought.
Because we can see it at the end of the judgment, 6725. I propose to grant an injunction, but to confine it to restraining the defendants from holding the confirmatory meeting.
Yes. Now, so they were able to get the injunction they were seeking to, in effect, to prevent the confirmation taking place. But in terms of the legal analysis of what principle is engaged here, it's the directors' fiduciary duty, we submit, their obligation to exercise their powers in accordance with the proper purpose rule, which is an incident of their relationship vis-à-vis the company. And if you go to Howard Smith and Ampol, and we'll come back to this because my own friend relies very heavily on the standing issue, but if you just look at the question of how the legal principle was identified, it is again put in terms of the exercise by the directors of their powers as fiduciary powers. Howard Smith and Ampol is at 5944. And the relevant passage for these purposes is at 5957, A34B to C.
Sorry, 5957, did you say?
Sorry, 5957, exactly. So A34B to C within the report itself. And this is how the legal principle is identified. And Wolford says this. Thus, and this is not disputed, the issue was clearly intra vires the directors. So it was obviously something they had capacity to do. But intra vires, though the issue may have been, the director's power in this article is a fiduciary power, It remains the case that an exercise of such power, though formally valid, may be attacked on the ground that was not exercised for the purpose for which it was granted. And then he refers to the contentions of the parties who were advanced in that case. So again, the way in which the question is analysed is in terms of the exercise by the directors of their fiduciary power, which is granted to them by the company. And in our submission, you get exactly the same analysis. I'll just give your lordships the references from the High Court of Australia in Ngurli against McCann, which is at 7466 to 7467 of the bundle.
So could you just give me the page again?
7466
7466
to 7467.
Yep.
So it's High Court of Australia.
Yep.
And then also the High Court of Australia in White House against Carlton Hotel, which is at 7603 of the bundle.
That's the relevant passage.
Yes.
Thank you.
Now, I appreciate my learned friend relies on the fact that in these cases it has effectively they've gone through on the basis that the majority shareholder has been able to bring the action. In fact, as we'll see probably tomorrow, Ngurli was an example quite clearly of a derivative action on the fraud on the minority exception. And White House was in fact an action by the allottees of the shares, or proposed allottees of the shares to rectify the register. Howard Smith we discussed and we'll come to again tomorrow. But the key point for this purpose, the purposes of this part of the argument, is that the legal cause of action, which is identified as regulating the exercise of the power to allot and issue shares, is this fiduciary power between directors and the company, which is given to the directors to exercise on behalf of the company. And the directors stand in a fiduciary position in relation to that power with the company and not with individual shareholders. So, as we say, I mean, absent identifying something else, one starting position has to be that the proper plaintiff in respect of this cause of action is the company, not the individual shareholders. And it's in some ways as straightforward as saying, well, if you've got an action in relation to exercise of a power for an improper purpose, then your proper plaintiff is the donor of the power. Now, it is important in our submission for your lordships to have in mind what the pleaded case is in terms of identifying the cause of action. Obviously, this is a...
Just before we move on,
yes.
Looking at Ngurli, may not depend upon who's actually done the thing which is being challenged. In Ngurli, the passage which you just referred
yes.
to actually starts on the previous page at 7465, about 4 lines up from the bottom, where it says there are 2 lines of cases where the courts will interfere to prevent the abuse of powers conferred by Articles of Association.
Yes.
One is where it's necessary to prevent majority abusing the powers of general meeting,
yes.
And the other is where it's necessary to prevent directors acting otherwise in accordance with their fiduciary powers. Yes. And he goes on and focuses, because in that particular case, as it usually is, it was the directors who went wrong.
Yes.
But he's treating, as I see it, really, it's all under one general heading of abuse of the powers conferred by the company's articles, if you like, let's call it unconstitutional behaviour, just as a label, which may be committed by any of the organs to which those, or either actually, it's usually either the general meeting or the directors, either of the organs of the company to whom the exercise of those powers on behalf of the company is conferred.
Well, if I just come back on that.
I think your submission is that this is all really about a cause of action against directors.
Yes.
Whereas taking a deep breath and reading the whole of that section of this judgment, one might say it's a cause of action arising from abuse of the constitutional regime established between the company and its shareholders under the articles.
Well, in our submission, there are two distinct lines of authority at play here. The first is the proper purpose rule, which applies in the trustee and fiduciary context between the company and its directors. Where you're talking about the exercise of the powers of shareholders in a general meeting, there is the principle that the majority must exercise their voting power in the best interest of the class as a whole.
That's one aspect, or they mustn't oppress.
Exactly. But in our submission, that is a distinct principle which you can effectively follow through from Allen and Goldreeves. I think your lordship actually, in the Senegan case, went through a lot of the...
You were there too.
I was, yes. Your lordship went through a lot of the juridical foundation of that principle, but it doesn't have anything to do with the trustee or fiduciary relationship. It's effectively a principle.
True. But in both cases, an individual shareholder, without going through the derivative action process, may ask the court to intervene.
Well, if in the context of a shareholder meeting, the shareholders have acted oppressively vis-à-vis an individual shareholder, yes, I would accept that they could apply to court to say the Allen and Goldreeves principle has been infringed, and they're doing that as the participant in the meeting who's effectively been subject to the breach of the Allen and Goldreeves principle. But that's not what's relied on here.
But it's only a principle which enables them to get the court to interfere, because it's part of the, whatever you like to call it, contract, constitution, regime under which the company is to be run under the articles of which they've all signed and which they're entitled to rely upon.
Well, in my submission, I'm not sure it is dependent on that, because it's. I would take, for example, a creditors' meeting, nothing to do with the articles, but that principle would apply equally to regulate the behaviour of creditors. So it's not. If I respect this, it's not a principle that really sort of derives from the articles. What it derives from is the general idea that where you're exercising a power in a meeting of that nature.
Through a majority. You might call it a majority rule constraint.
Yes.
But in the context of a company, it will have its expression in what the shareholders do.
Yes.
But, I mean, that is exactly, coming back to the pleaded case, that is exactly what is said in this case about the resolution passed on the 30th of October 2018.
Yes, but at the EGM?
Yeah.
Yes.
So if you were, as I understand it, you're not relying, for present purposes, on that resolution.
For the purposes of this strikeout application.
But if you were,
yes,
then what has just been exchanged between my lord and yourself would apply in this case, and you're not seeking to challenge as a matter of legal analysis. Paragraph 65, I'm sure there'll be a great deal of argument on the facts.
Yes.
But, I mean, your case is solely based on saying that the director's decision is incapable of challenge by a shareholder.
Exactly.
Just because there is no cause of action.
Yes. And of course, on the facts of this case, it was the directors who caused the bonds to be issued, which is ultimately the foundation of the complaint here.
Having been authorised to do so by the resolution, but we leave that.
Well, the resolution, I think, came subsequently.
I had the impression that the shares were issued on the same day, and I assumed that, because they had to accelerate the issue of the shares under the bonds, didn't they?
Yes, I was talking about the issue of the bonds, which I think took place, which is effectively fired the starting gun on all of this. Now, so far as the statement of claim is concerned, and identify what is said to be the legal cause of action which is relied on. We deal with this in paragraph 7 through 13 of our written case, and I don't want to weary your lordships too much with a pleading point, but ultimately this is a strikeout which was brought by reference to the pleadings. Obviously, we accept for those purposes that the pleading case would be established at trial. And in our submission, we set out in the written case, if you look at the legal nature of the cause of action that is pleaded, it seeks to advance a cause of action based on breach of the proper purpose rule, in respect of which the company is the proper plaintiff. And it's not sought to be brought as a derivative action, and in any event, the necessary permission for bringing a derivative action hasn't been sought.
Sorry, when you're referring to the statement of claim, which bit of it do you...
So it's essentially the bits we identify. If you've just got our written case to hand at paragraph 8, which is 5057. I'm sorry, I didn't read out the electronic bundle reference. And we sought to identify in paragraph 8 the parts of the amended statement of claim, which as we read it, set out constituent legal elements of the cause of action. I appreciate there's a lot of material on the facts. But what we submit is pleaded is essentially that the bonds and then the subsequent issue of the shares were issued by the board in breach of their duty to exercise their powers for a proper purpose. And in our submission, that is a cause of action that belongs to the company and not one that belongs to individual shareholders.
Although in Eclairs, it was exactly that cause of action that was asserted, wasn't it? Admittedly, the misconduct is different, but that which made it actionable was that it was in breach of the proper purpose rule.
Yes.
And yet, in that case, the Court of Appeal didn't only hold that the shareholders could sue, they held that the ultimate beneficial owners of the shareholders.
Yes, on a sort of beneficiary type derivative action. Well, I don't have I'm not in the position of being able to look at the pleadings in Eclairs, but...
It's not really a pleading point, is it? It's just about whether there is a cause of action or there is a claim. I mean, if there is one, you're not saying they can't assert it because they haven't pleaded it.
No, we're looking at the person looking at the pleading.
I mean, this is a personal action by the shareholders, and either there's a right to bring one or there isn't.
Exactly, and the purpose of looking at the pleading is to seek to identify what they say the cause of action is. And
yes, because in a strikeout application, you have to look at the...
Yes, exactly, which is why I'm wearing your
But I mean, they do...
doing exactly that.
I mean, they do in paragraph 13 tie it to the articles, albeit by means of an implied implication, but they are basing it on the articles.
Well, I was going to come to paragraph 13 because that is the one part of the pleading where there is a reference to the articles, and we deal with this in our written case. And your logic is absolutely right. If we go into paragraph 13 of the statement of claim, paragraph 15 of the bundle, that's where you see it. Now, so if we go paragraph 15 of the bundle, please.
Page 15.
Page 15. Sorry, page 15 of the bundle, 1.5. Paragraph 13, the statement of claim. Yes. So this is the sole term of the articles that's relied on, so that there isn't any reliance placed on any express term of the articles as forming part of the cause of action. What is relied on is this implied term. And in our submission, there's two problems with this. The first is there simply isn't any basis for the implication of a term of this nature. Indeed, in my oral submission, in his oral submissions, I didn't understand my learned friend to be relying on an alleged implied term in the articles.
Well, there's a whole line of contract cases, isn't there, which says that there's an implied term where you have a discretionary power in the contract. It will be exercised for proper purposes. And it seems to me that this is a similar sort of argument. Sockimer, exactly, that's an example. Brigands,
yes.
By now, there's probably 50 of them, actually.
Yes, although that's not what they've pleaded here. I mean, what they've pleaded here is...
You've got to read it with paragraph 12, haven't you? What he's saying is that the power to issue new shares was conferred by the articles on the directors, that is the board, who are fiduciaries. And it flows from that, doesn't it, that under the articles, the issuing or not issuing of shares, or the allocation or non-allocation of shares, or the choice as to whom to allocate the shares, must be conducted in accordance with fiduciary principles. But because they are the board, they're directors, and it's perfectly obvious from the articles they're fiduciaries.
Well, in our submission, it's not necessary to imply that in at all, because as between the company and the directors, it undoubtedly is the position that what your lordship said is right, because vis-a-vis the company, the directors stand in a fiduciary position. But there's no basis for implying a term that effectively extends that to individual shareholders as well.
No,
it's express. If you confer a power by your article of association to do something which may affect you on a body of people who in fact are fiduciaries, it's express, isn't it, that they're going to exercise their powers as fiduciaries, and that means they mustn't do it for an improper purpose. But
the beneficiary of the power, the donee of the power, is the company and not the individual shareholders. So, I mean, if you follow it through as a matter of the company's constitution, the power to issue or allot the shares and the bonds is set out in the memorandum, was derived from the memorandum of association. And then under the articles effectively say that that power of the company may be exercised by the directors. And as a consequence of the company giving that power to the directors, they undoubtedly owe the company a duty to exercise.
That's the articles that provide that the power is to be exercised by the directors.
Yes.
So it arises really by operation of law that the directors is to exercise that in accordance with their fiduciary equitable duties.
Which they owe to the company.
And the point I'm trying to
suggest
is it's not just that the company has said to Mr. So-and-so, I appoint you as a director.
Yes.
Like a settlor or appoint somebody as a trustee of a trust fund.
Yes.
It's actually embedded in the articles of association, which binds the company and all its shareholders that this is how it's going to be done.
Correct, but then the question is, well, why is it? It's said that means that, in effect, the proper purpose duty is one that's owed to individual shareholders.
Well, I think you accept that in some circumstances it is. For example, in Eclairs. I mean, because you accept, I think the discussion earlier said, well, this is a different case from Eclairs. Because in Eclairs, the power to disenfranchise was exercised specifically in relation to the claimants in the case.
Yeah.
I think you said, well, that made a difference, and they were entitled to maintain an action to set that aside.
Yes.
But they set it aside on the basis that the power had been exercised by the directors in breach of their fiduciary duties, which, as you say, are duties owed not to the shareholders but to the company.
Well, one would need to, I think, probably to look at the articles in Eclairs and
I think we know them well enough that in certain circumstances the directors had power by notice to disenfranchise the shares.
And that particular power, if it's directed at a particular shareholder...
Well, that's the point you make, I think. I think you're saying that what makes the difference is not that there's an exercise by the directors of fiduciary duties or a failure, but that the exercise of the power is directed at a particular shareholder.
Well,
because otherwise I don't quite see how you can say that Eclairs was correctly decided.
Well, it's really for my little friend. I mean, our proposition is that if you start from a blank sheet of paper, and you give a power to the directors to allot shares, then starting position is you wouldn't expect that to give rise to a cause of action owed to an individual shareholder. So you have to ask yourself, well, what is it that effectively moves you from that default position and creates the cause of action in favour of the individual shareholder? There may be certain circumstances like Eclairs where specific power is exercisable by reference to specific shareholders, and it may give rise...
It's exercisable in relation to any shareholder who fails to provide a satisfactory answer to the question about ownership.
It is, or it is in fact exercised.
But is it in fact
individual shareholders?
I mean, fundamentally, I mean, I find it very difficult to see that Eclairs is compatible with the reasoning in the Court of Appeals judgment here, which I understand to be based on your submissions, that these duties are fiduciary duties owed to the company.
Yes.
And that's the end of it.
Yes.
But I think you're perhaps moving a little away from
No, I mean, as I say, our starting position is that where you've got an improper allotment.
Well, what about an improper enfranchisement notice? Improper because the directors have acted in breach of fiduciary duty.
Well, without looking at that, I think it's perhaps a little difficult to look at the abstract. I mean, one would need to look at what the power in the article says, and if it's
we've all looked at Eclairs.
Yes, I mean here you have just a general power to issue shares given to the directors generally, and in our submission that itself doesn't involve necessarily the creation of a duty owed to individual shareholders. It's the donee of that power is the company. Now,
but this case doesn't assert a claim against the directors. This claim asserts a claim against the company.
Yes, it does, exactly.
Because it has done something at the direction of its directors.
Or through the agency of its directors.
Yeah.
Exactly, sorry, yes, through the agency of its directors. And there is a list between the company and the shareholder, because the company says it's perfectly okay, and the shareholder says it's not.
Exactly. Well, this is exactly our point.
Future board meetings on the basis that these new people don't have votes.
Yes, I mean, so this is exactly our case. This case turns on identifying a cause of action between the shareholders and the company.
But I think what this discussion reveals is that it's not a question of saying that the director's duties are owed to the company, which is, as I understand it, how you were putting your case, so much as looking at the particular power exercisable by the directors and saying it's as a result of that analysis that you decide whether an individual shareholder has a cause of action or not. But the underlying complaint in Eclairs is the same as here, namely, the power has been exercised in breach of duty. And you're distinguishing it not by reference to that, but by reference to the nature of the power.
But
both of them are fiduciary.
But you can't distinguish, in our submission, you can't distinguish the nature of the power from looking at the duties.
But the duties are the same. They're all due powers which must be exercised for a proper purpose.
Well, no, because the question we're on here is to whom the duty is owed. And
no, but forgive me, on what basis do you say that in Eclairs the directors owed their fiduciary duties to the shareholder?
Well, this point was not, as far as I understand it, explored in Eclairs, the question of whether the duty was owed to the...
Are you saying it was wrongly decided?
Well, the point wasn't argued.
I think everybody assumed the duty was owed by all directors, other duties owed to the company.
Yes.
But the question was whether the shareholders, or rather the beneficial owners of the shareholders, could ask the court to intervene where something which affected them had been done in breach of the duties which the directors owed the company.
Yes.
And the company was a defendant.
Yes.
There was no attempt, it wasn't a derivative action.
Yes. And I accept if you've got a specific power which is capable of being exercised on the face of the articles by reference to the shares of individual shareholders, so you've got a power to disenfranchise a particular shareholder, then one can see the argument that in relation to that power, you can say, well, there is a duty owed to the specific shareholder.
By whom?
By the directors.
So you
didn't sue the directors. I mean, they didn't do
exercise the power.
But the duties which were at the root of Eclairs, and they've shown us the passages, are the normal fiduciary duties owed to the company.
Yes.
They wasn't put on the basis of any duties being owed to the individual shareholders.
Well, maybe we need to have another look at the nature of the power in Eclairs, but I go back to my...
What, is that something that we can return
yes,
to
we certainly can.
in the morning?